Defense made a motion for a mistrial. Prosecutor was up to some fuckery. Potentially damaging evidence, no basis for it. The judge specifically said, do not ask that question. Do not use that as evidence. She walked right down the path and asked the question. It may be over on Tuesday morning. Batman Bruce Wayne bitch snitch. Gerald Brooks, your constitution does not apply to me because I'm a sovereign citizen, a traveler on the land. I'm the Moorish Empire or whatever, bitch snitch. Because they're so fucking absurd. If you want to be a sovereign citizen, just do yourself a favor first. Go to YouTube here and just get every sovereign citizen that's ever been before. Find me one that won. God dang, you're right. Don't go down this. It's not the path. Don't have time for stupidity. Some clever dick on the internet didn't find the great loophole in all of the world's law. Bitch snitch. God dang, you're right. God dang, you're right. Traveler on the land. Moorish Empire, traveler on the land, bitch snitch, Moorish Empire, God dang, you're right, traveler on the land, bitch snitch, late evening West people.
What do you got?
I think I can prove to a judge that both of these men had the mens rea.
What the hell is a mens rea?
It's a legal term the lawyers use. It just means the intention to commit a crime.
Okay, come on, let's go.
Mens rea?
Put the cuffs on him.
How could we have gotten mens rea? We take blood? Can you do it without taking blood? We both use condoms. How is this possible? I want to see a doctor. Can I have an independent blood test?
Money!
I feel sick.
What are you doing?
Mens rea! Oh! Oh! My God! No!
Hey, good morning, good afternoon, good evening, and all that other stuff. Whoever you are, wherever you are, whatever you're doing, I hope you're having a great Friday evening here with me if you happen to be in the States, or a great Saturday morning if you're over here in the eastern side of the universe, Australia, Japan, Korea, that sort of thing, and a good middle of the night if you're anywhere in Europe. It is Saturday morning here in Korea, and we are going to get into some Sarah Boone motions and hearings today. She had a hearing about a week ago, with the first hearing where she was representing herself. And since then, she's filed a bunch of motions. And spoiler alert, she wins at least one of them. So score points for her, I guess. We're going to take a look at those. But first, let's see. We got our housekeeping stuff. It'll take me a while to catch up. It's 9 o'clock in the morning here, and my night ended about 4 o'clock in the morning. I got invited to a very, very exclusive whiskey and cognac tasting last night with the folks, the good folks from Moet Hennessy. We were sampling $2,500 bottles of scotch and a $3,500 bottle of cognac that came in a solid silver bottle. It was just decadence, and the best part of all, it was free. So that was a very special thing. It was great to taste stuff that I'm never ever going to be able to taste again. And then after the tasting, then it just kind of got, here, have some whiskey. Yeah. So I woke up. It's 9:11 now. I woke up 15 minutes ago. So here I am. Here we are. It was good. And there was 4 super expensive things. The idea was they were it was a marketing thing where they were inviting VIPs, trying to convince everybody to go in together and purchase an entire barrel of 23-year-old Glenmorangie. Sounds like a good idea, but the price tag for the barrel of 23-year-old, and for a barrel has about 182, somewhere between like 180 to 200 bottles in a barrel. Sounds good here. Like everybody pitch in and get a bottle. I mean, get a barrel of scotch, 23-year-old scotch. Flux asks, "Did you do it?" Hell no. The price tag for that was about roughly $300,000. Yeah, that ain't gonna happen. Depending on several factors, it would range between like $300,000 and $350,000 for an entire barrel of 23-year-old Glenmorangie scotch. So yeah, I just enjoyed the free, really expensive whiskey. Yeah. So yeah, there we go. But it was a good experience. Like, thank you very much for the free scotch. And cognac. I'll be leaving now. But all right. So yeah, it's expensive. On the other hand, if you want to buy an entire barrel of Jack Daniels, it's going to cost you about $7,500 to $8,000. So you can have lots of Jack Cokes with that. Yeah, buy a nice house or a barrel. Jeez. All right, peeps. That's enough of what I was doing last night. We've gathered 200 people here. It's time to get into Sarah Boone. Hey, is it too early for the phrasing button? No, it's never too early for the phrasing button.
Phrasing.
All right, we're not going to get into Sarah Boone. We're going to talk about her story. And if you are with Sarah Boone, don't get into anything with her, especially not suitcases. Well, okay, so we've got our like and subscribe poll here. As always, it's just to remind you to hit the like and subscribe button. So please, as it says like, please, as it says subscribe. And again, YouTube is putting me through the time of testing. We're about 70 down. We're getting more subscribers, but they're just getting rid of them faster. So please double check to make sure you are still subscribed if you haven't already done so. And people that are here now and people on replay, if you aren't subscribed, please do me the favor of hitting that subscribe button and take our like and subscribe poll. Sarah Boone, best jailhouse lawyer. Sarah Boone, spokeswoman for Samsonite luggage. Sarah Boone, international human smuggler. Sarah Boone, just batshit crazy. Those are your choices for the poll. We'll check back in about an hour and see how that's going. Well, so again, I'm in hydration mode. I know people in America know this, but do people outside of America? Are you familiar with the orange flavored beverage Tang? I mean, growing up, that was the shiz, because it was what the astronauts drank during the Apollo program days. They drank Tang. Well, I just happened to see some here in Korea, and just for nostalgia, for those of you that don't know what Tang is, this is Tang here. Tang. It's like really watered down bitter orange juice. As I recall, I have not had Tang in probably 35 years. So we picked, and by we I mean me, picked up this lovely powdery beverage, and we've got it here. So you know, this is orange drink. despite the fact it's sort of an interesting shade of like brownish orange. So yeah, I haven't had it forever. So I just bought it for nostalgia's sakes. Just as I recall, a little gritty, a little watery, but kind of bitter at the same time. So I do have my stevia simple syrup. Just put a little bit of that in. That should sweeten it up a little bit. For our Boone trial, we got to have our beverage for this. All right. Oh, much better. Nothing like a Saturday morning with a mouthful of that sweet Boone tang. See what I did there? That was a long setup for a good joke, wasn't it? I played the long game with that one. My sweet Boone tang. All right. Sorry. I apologize. I'll make sure that doesn't happen again today. See, that's what happens if you skip the first 15 or 17 minutes of my show. You miss that sort of stuff. By the way, it's not even tang. It's peach mango crystal light. I lied to you. But all right, we got Jay No, who's been a member for 12 months, a solid year. Thank you so much, Jay No. Hey, Kurt's in chat. What's up, Kurt? Uncivil law and his uncivilians. Jay No, member for 12 months. Before taking the poll, don't forget to subscribe. Don't forget to subscribe, hit the button, and most importantly, huck toss, spit on that thing. Yeah, there we go. Julie O, Sarah Boone, hide and seek world champion. Well, her boyfriend was the hide and seek champion. He just never. He's still he's even hiding underground now. Sarah Boone, hide and seek world champion. Thank you so much, Julie. Oh, member for 22 months. Bush McFadden said Jeff is now Matt McCabe. All right. Hey, Jules, what's up? Hey, everybody. Alan Walsh. Everybody else. B.S. Simon. Thanks you, Jeff. What? What do you want, dog? What are you barking at? Just go get your stupid ball, you dumbass. Apologies. Before we get going, Strawberry wants a ball that's stuck behind the studio lighting tripod here. So that's it. Once we finish up with these super chats, we will start in with the hearing. Most recent hearing. All right, I'm stretching. There you go, dog. It'd probably be easier if I took my headphones off. There we go. All right, there you go. There you go. Straubs has her ball. All right, I'm back. Sorry about that. Y'all settled in there, guys? All right. As I was saying, we're going to be doing the hearing. Her first motion. It's two separate filings with multiple motions. And as I said, spoiler alert, she wins at least one of them. 200-watt studio, how you doing? It has been a moment. I always wondered why Sarah wanted to bring an empty suitcase on her vacations. She said she was just in case. I thought she meant shopping. I used to bring the empty suitcases whenever I would come from Korea to America. It would be two very empty suitcases, and they would come back full of lots of American goodies. But now we can get pretty much everything here. Just... not people. 200-watt studio again. I heard his funeral was open suitcase. Is that what we're doing today? Is that what we're doing today? We're doing Boone jokes. All right. Keep them coming in. Oh, by the way, this is not a grift. This is just a simple fact, a simple statement. I actually got a comment the other day saying Super chats are a good way of supporting, but we don't want you to take their 30%. So you should put us links to your other things. And my response was the mods are always putting up the Cash App, the Venmo, the PayPal, the Zelle. They're always putting theirs up, and they can always be found. All of those goody old links can be found in the description below here. So if you want to do all of that, please feel free. There's the alternative payment methods that are all nice and neat and always linked and always brought up by the mods. Right. Boone jokes. Let's jump into this, shall we? On the I believe it was the 25th of July, she had her first hearing representing herself. Because for those of you that don't know, she is, I mean, I'm not sure how you don't know Sarah Boone, or why you're here, but we got, for the 300 people here, I'm sure there's some people that don't know who Sarah Boone is, or exactly what it is she's alleged to have done. She had a bit of she's divorced. She has a new boyfriend, very past tense, had a boyfriend. They apparently were a toxic couple. The police had been called to the residence several times. This one night, they decided to have a few bottles of wine, and they did. They drank their wine, and at some point, I guess things turned a little bit sour. Oh, Jill Ems knows nothing. Well, you're about to learn, Jill. Things turned sour for the couple, like more sour than normal. He said, the police have been called. Well, after drinking a bit, allegedly, well, I guess she kind of even admits this, that somehow she convinced him to get into a suitcase. She zipped the suitcase up. And there's two options at this point, allegedly, from the state's point of view. One, she just left him there on the first floor to die, knowing he was dying. The other theory is she convinced him to get into the suitcase on the second floor and then pushed him down the stairs inside the suitcase and then left him on the first floor to die. JKD Bucks has an airtight case. No, it's too early for that. So, she basically admits that she put him in there and he got in there and it was zipped up. Her defense is, I forgot. I was too drunk and I forgot and I went to sleep. And then I woke up and he wasn't there and I was looking for him and then I found him and he was all dead. But this is not legal advice, but it's very sound practical advice. Just, common sense. If you're going to be doing this, if you're going to engage in such activity, don't record yourself doing it. Don't make a TikTok video of you doing it. She has this recorded. It was recorded on her phone. She recorded, and this, as I've said since the recording came out, is one of the most evil recordings I've ever seen. It's just her sitting, holding the camera and the luggage sitting there in the living room at the bottom of the stairs. And she's going, how does it feel? She's just mercilessly just laying into the guy verbally. And, how does that feel? It happens when you cheat. That's how I feel when you do this to me. And inside, as you saw in the thumbnail, he's inside the suitcase and you can hear him going, Sarah. And at the very end of the video, you just hear this, Sarah. Shh. And then the video ends. It's creepy AF. Like that's the last thing you hear is like gasping, very quietly calling out her name, and then her just going, shh. And the video ends. It's wild. So regardless of what you may think, regardless of what you may hope, regardless of the fact that we have to go into the trial with a presumption of innocence, she's getting convicted. She's going down for this. She will, I can say with 100% certainty, going to be found guilty. But with her, it's not whether she's going to be found guilty. It's whether this damn thing is ever going to get to trial. This is almost 5 years ago. It's like 4 years ago. And she has a way. This is her, again, for those of you that don't know, this is her, she is her own ninth lawyer. She went through 8 public defenders. And they were all terrible. They were all mean. They all hated her. None of them cooperated with her. It's one of those deals where if you're in a room if there's 10 people in the room and 9 of them are assholes, that's a pretty good indication as to who the actual real asshole is. Because she's had 8 public defenders. They were all assholes. They were all terrible. They were all jerk. They were all jerkish. So the judge said, well, you've had 8. And a lot of times you get, you always get 1 if you need it. 2 possibly. 3 is pushing it. And pretty much from then on, the judge is going to say, look, you got a choice. Go with what we've given you or go it alone. But this court gave her 8 of them, 8 public defenders, before the judge finally said, look, we've given you everybody you're going to get. You've exhausted your right to have a lawyer appointed 8 times. So you're on your own. And that leads us to where we are today. Uncivil, seriously? Uncivil Kurt says that a person closely connected to her, sent me an email asking me if I wanted to represent her. Serious thought about it. Not the best way to start your courtroom career, I would guess. I always want to try to start with a win. All right, so let's do a couple of things here. Then I promise we're going to get to the. We had to give a little bit of a background because there were people that were unfamiliar with this case. We did that. 200-watt studio. Too bad you didn't work for the TSA. They can get in and out of any suitcase. And somebody would probably steal him too. That's the thing. Lugmeister with the Nokia, with the 50 Nokia monies. Thank you so much. Irony that your boyfriend ended up in a suitcase by a basket case. Ooh, saucy take. In a suitcase by a basket case. Talos Saphirian. Welcome, Talos Saphirian. With a 25, you get a big old foghorn for that. I'm afraid. Not afraid. You get a big old foghorn. Sad that I won't get to say hi to you again at Anime Matsuri in Houston this week. But I will look at all the Godzilla stuff in spirit for you. Also looking forward to hearing about this motion. Have a good weekend. Man, yeah, the Anime Matsuri starting in a week, I think. Yeah, it's going to be about 100 degrees, or like 37 degrees Celsius. It's going to be about 100 degrees Fahrenheit here today, and it's about 60%, 70% humidity. Ain't no way I'm leaving here to go to Texas in the middle of summer ever again. I'll visit Texas in January if I ever visit again, but it will be sad to miss it. Island with the $2. This is why you should avoid dating people with baggage. Oh, yeah, there you go. That's a good one. 200-watt studio. She should have taken luggage to the airport. 50-50 odds they lose her luggage. You're not wrong. And Jenny LJ gifted 5 Legal Vices memberships. If you're one of those 5 Legal Vices membership winners, make sure you give Jenny a super special thanks. That would be John Gordon, John H. 2004, Brad, Crystal Love, and CD. All right. Now I've exhausted everything. It is time. It's time to start the hearing. This is the hearing from, I believe it was exactly a week ago. So let's see how she did for her first hearing all by her little old lonesome, shall we? Let's hey Sarah, what's up? What's up, Sarah? It's embiggen Sarah. She looks like a doctor there with like she got her name tag on, she's got the hospital tag on her wrist. But kudos to them for giving the ladies a little fashion. The prison giving the ladies a little fashion, letting them rock the pink handcuffs. That's mighty kind of them. Here she is. Mr. Cacciatore?
Dave Cacciatore on behalf of the state.
The dude for the state's name is Cacciatore? By the way, I haven't seen this. So we're this is a live reaction. The guy's name is Cacciatore. Insert chicken jokes here. We got chicken jokes, we got Boone jokes, we got it all. Talos is a new member. What's up? Thank you so much. And 200 Watt Studio. He wouldn't stop talking. He would just carry on. How old is this woman? I don't know. Somewhere maybe mid 40s. All right. Insert kitchen cacciatore. That's a new dish if you've never had it. It's kind of like chicken cacciatore. And anyway.
Ms. Boone, good morning. Could you please raise your right hand so Madam Clerk can swear you in?
Yes.
Ma'am, good morning. Could you state your name and date of birth for the record for me?
Sarah Boone, 10-10-77.
We also have a representative from Prison Break Investigation. Sir, if you could come forward, please.
Why did you do that, camera? Why would you do that? Don't ever do that again.
If you could, sir, raise your right hand. Madam Clerk's going to go ahead and swear you in. All right, sir, good morning. Could you state your name for the record?
Billy Lane.
And Mr. Lane, what's your affiliation with Prison Break Investigations?
I'm the owner and chief investigator.
Okay, very good.
All right, we have one of these very famous courtroom situations where the judge is loud and you can't hear anyone else. So we're gonna have to make the judge, I think, a little uncomfortably loud, so that we can hear the others. We'll put it about 250% and see how that sounds. But that should be okay. But I didn't need to see that Zoom. So I think it's interesting. The investigators that are handling this for her is a Prison Break Investigations. That is the most kitschy, lame name for an investigation service. Prison Break Investigation Service.
Good. The reason the court had this hearing this morning is the court has found that Ms. Boone has forfeited her right to counsel and waived her right to counsel alternatively by virtue of her conduct in this case. As such, Ms. Boone is currently representing herself. The court has been working diligently to provide you the discovery. I received your letter, ma'am, and I have reviewed it. We have not forgotten about you. It's just taken some time in order to
we haven't
coordinate
forgotten
the
about
appropriate processes with the jail. In conversations with the jail, a laptop has been secured and will be.
Okay, so she gets a laptop. What he's doing is he's letting her know what her options are, how they're going to handle her computer time, and I guess her discovery and other things that relate to her being able to prepare for her own defense.
Issued to you after USB drives are provided with all the discovery. Upon the jail's receipt of those items, the following provisions will be adhered to. The laptop, charging cable, and USB devices will be kept in the FDC main control room when not in use. At no time will the charging cord be placed in the housing unit. Upon the return of the laptop to the FDC main control, the laptop will be placed on the charging cable to ensure it is available for the next day's usage. The laptop and USB device is to be accounted for with the control room inventory. The control room DST or CO will make logbook entries for the issuing and returning the USB device and laptop. The dorm officer will make logbook entries for the receiving and returning of these items to the applicable movement officer. A notebook entry will be completed in IMS for every issuance of the laptop and USB device to inmate Boone. The laptop and USB device will be available daily to you, Ms. Boone, between 0800 and 1600 hours.
Okay, that was the question I was going to ask. I was going to say, what is, making it available to her and making it available to her for a reasonable amount of time are different things. I mean, say, yeah, we're going to give you a laptop, but you get to use it for 30 minutes a day. That would be an issue. But I think 8 a.m. to 4 p.m. is a reasonable amount. It's a work day. It's a business day. But again, what if she wants to work late one day? What if she's a night owl and she enjoys just like staring into the darkness in prison, and in jail, and she would rather work on her case overnight? It is somewhat limiting, somewhat restricting, but she's also in jail. So there are the restrictions that there's the overlapping issues of unfettered access to be able to prepare for her own defense, as well as having to live with the strictures that are placed on her as someone who happens to be in jail at the moment. So I think 8 to 4 is reasonable. I may argue that 6 p.m. or whatever evening chow time is would be more reasonable.
Entry will be completed in IMS for every issuance of the laptop and USB device to yourself, Ms. Boone. The discovery was provided at the court previously, and is in the two banker's boxes that are in front of the court to your left, Mr. Lane. I'm going to order you, sir, to take possession and custody of that discovery that was provided to the court previously on June 28, 2024. You, through Prison Break investigations, shall copy all of the discovery onto as many USB jump drives as necessary. The Judicial Administration Commission for the state of Florida shall be responsible for the fees and costs due to Prison Break investigations for copying all of the discovery onto as many USB jump drives as necessary.
How much, dude? You can get I think you can get terabyte thumb drives now, can't you? How much discovery is there that there might need to be multiple thumb drives?
You will appear for a hearing with the court on August 1st, 2024 at 8:45 in courtroom 12A of the Orange County Courthouse with the discovery and all USB jump drives containing.
Oh yes, there's going to be a jury.
A representative from the Orange County Jail shall also appear for that hearing as well. At that point in time, Prison Break Investigations shall hand deliver all USB jump drives containing the discovery to the representative from the Orange County Jail in order to be placed onto the laptop that is currently secured and to be issued to the defendant for all trial and court preparation. Do you have any questions for me, sir?
I have a conflict for August 1st, Your Honor. I'm
Okay.
going to be out of state from Tuesday until Friday of next week, which I believe is the conference August 1st.
Court, see that thing here on the floor next to his right leg? That's a microphone. Perhaps we could use it. Perhaps it would be beneficial if you would put that microphone up on the lectern. That would be helpful. But so basically, they're saying that this is the investigative company that is working on behalf of Sarah. They're her investigator, and they're going to be the ones that are going to get the discovery and deliver it to the jail and attend to hearings and stuff like that. So he's just saying, hey, you have this hearing upcoming. I got a conflict.
For my son's wedding.
Okay. Well, congratulations.
Oh, his son's wedding.
When do you return from your son's wedding, sir?
I will be back late Friday evening, so I'll be available the following week.
Okay. Will you be able to complete that task by that time? Okay, sir. We will see you on give me a second. I want to make sure I get the date right. Monday, August 5.
There we go. The next hearing will be this coming Monday. I believe it's 1:30 Central. I'll have to double check on the time, but it will be Monday afternoon is the next hearing.
8:45. Okay, you'll be given a copy of the order that I just read from. Ms. Boone, you'll also be given a copy of the order. Do you have any questions for me?
I am thoroughly confused.
You don't say. You don't say you're thoroughly confused. Who would have guessed that? All right, before we hear why she's thoroughly confused, pretend judge. Hey, pretend judge, what's up? For Sarah's toilet hooch fund, you know, we always like some toilet hooch fund. You can never go wrong with toilet hooch. John Gordon with the $2. You're saying they zipped her up with that limit. Yeah, you could say that. 200-watt studio again. Oh no, come on. She never works on her case overnight. Yeah, she might work on her suitcase overnight. Eastern time, it's Florida. Okay. I get for some reason I thought the thing was mentioned in Central time. I must have been confused. I know it's Florida, but anyway. Is it 1:30? Is it 1:30 p.m.? Oh no, it was mentioned in Eastern time. But I did have to check and see for something about Central time to see whether I could get some sleep. That's what it was. All right. Well, what we're gonna do here real quick is let's double check this right now. The time is get that clerk side up open. First name Sarah, middle name Boone. I am not a robot. Search. There you go. State of Florida v. Boone, Sarah, criminal felony. She was born in 1977. Huh. There we go. Hearing. Where's the notice of hearing? The notice of hearing. Okay, order setting hearing. He probably just said it. I don't know. Opening the document. It is. Why would you not have the time? Hearing at 8:45 a.m. Okay, that was correct. Why did I see something in the afternoon? I was thoroughly confused. 8:45 a.m. Well, looks like we may have to postpone Maritime Monday. I'll have to think. We might have to have Maritime Tuesday this week. All right, there we go. Thank you so much. That is 8:45 a.m. Eastern time is her hearing on this coming Monday. Lancelot 652, member for 1 month, please. Someone email her a copy of the Soft Sit book. I want another Brooks. See, I'm torn about this. One, there's humor value in this. There's gonna be entertainment value in this. There's gonna be lots to talk and talk about, laugh about, giggle about, but at the same time, I don't like a mockery of the judicial system. I don't like the fact that was Brooks's big deal. He just made a mockery of the entire system. I want the swift, effective, and proper administration of justice. But I want the entertainment value too. So part of me is super thrilled she's representing herself, and part of me is really, really saddened and borderline offended that she's doing this. But at the end of the day, and you're probably going to hear me say this more than once, but at the end of the day, she brought this situation upon herself. So that's kind of my feelings. She's not going to be, no, she's not, because she's actually pretty smart, just not quite as smart as she thinks she is. Jules is correct. It's not going to be as bad as Brooks, but she is confused. She is thoroughly confused. I wonder what she's thoroughly confused at. Is it going to be a legitimate issue? Like, I'm confused about the process, which sucks, because when you represent yourself, you are presumed to have the same knowledge and skill relating to legal issues, relating to court rules and procedures as a reasonably competent lawyer. It's kind of a low threshold, but you're expected to have the same knowledge as a reasonably competent lawyer and follow the court rules. That's where a lot of self-representing people get in trouble. They can't. It's not the people's court. It's not Judge Judy where you get to jump up and down and yell and scream at willy-nilly as you see fit. There actually are real courts with real rules. So let's see what she's thoroughly confused about.
Was the notice ever put online for this or mailed to anyone? I don't even know why Mr. Lane is here. I don't know why I'm here.
Well, ma'am, you are now representing yourself, and previously you had requested to be.
You're here because it's a hearing, and you are, one, the defendant, and two, the defense counsel. That's why you're there. And I think he just went through it. This guy is your investigator. He's the guy that's going to investigate your case for you. He's the one that's going to handle the discovery. He's your liaison here. So you shouldn't be confused.
Appear at every hearing that was held. As you are now representing yourself, the court cannot have any hearings regarding your case without you being here. I put on the record and explained to you the process that the court has had with communications with the jail. I'm not allowed to look at any of that. I'm not allowed to copy any of that. So in speaking with the jail and understanding that you still have a private investigator that was provided to you through the state that's being compensated by the state, you're still allowed to utilize his services. The protections of the attorney-client privilege are still applicable to him. So he's able to review any of these documents, ensure that they are safely copied without violating any terms of the privileges. Those will then be placed on multiple USB drives and provided to you. Those USB drives will then be uploaded to a computer that has been secured for you at the jail for you to access all of that information.
Okay. My question is, was a notice of hearing posted or mailed to anyone to where?
Oh, she's arguing service. All right. She's arguing that she was not properly served. And I'm pretty sure the judge is going to tell her that she was.
The news crews obviously got it. How is it that I do not know anything about this other than my bunk being kicked at 3 o'clock in the morning telling me I have court?
Ma'am, I have no other way to get in touch with you other than setting the hearing, which was set yesterday once I received confirmation from the jail as to the processes for how this would work. And
so he's basically saying whatever happens, you were properly served. I want to. I'll have to call it a cot or a bed. I want to say like rack, but say someone kicking her rack at 3 a.m, that could be misconstrued. So it's almost apparently someone kicking her cot or her bed there at 3 a.m. saying get ready for court. That's your notice, because this is basically one day, I believe, after the hearing. After the previous.
I understand that your case is important, and I want to move as efficiently, as diligently as possible. I know that you've been waiting for this information, and it took some time to confirm the process with the jail. You've advised me that you have very limited space. You have almost no privacy. You have a small drawer where you can keep some personal effects. We could not send all of those boxes with you to the jail, and the jail advised me that they cannot take all those boxes. A process had to be created to make sure, and this is the process.
The process that I was explained after speaking to a couple of sergeants, and I've been waiting for that, and I would much rather prefer a hard copy of these to where I can write on them as opposed to anything that's on a laptop.
I am unable to provide that for you. I have been provided the process has been provided to me by the Orange County Jail. I understand that's your preference, but I can't do anything more than what I've done right now.
I understand. And I have had other information given to me, which is why I've been waiting for the boxes for them. So I don't know.
Well, here's what you do, Sarah. Here's what you do. You listen to the judge, not the jail sergeants. The judge is the guy that's going to be telling you how it really is. So he's the one you want to pay attention to. Potentially criminal. What's up, Sean? Potentially criminal in the house. The judge is inducing potential error via this delay to get her discovery and not extending the trial date. I agree with you to a point, but I think because I scanned through the motions as best as I could scan through her writing. I don't think she asked for a delay. I don't think she asked for a. She didn't make a motion to extend the time, to give her time to prepare. And so, it's, that's where I think she doesn't have a good argument there. We'll have to see if there's a motion to delay this. But if she doesn't ask for it, she doesn't get it. Danny on direct in the house too. It's a free for all. Hi everyone. Hi Danny. How are you? So yeah. I would agree if she'd asked for a motion. If she asked and is denied, I think there might be an appellate issue there. But I don't think she asked for it. We'll have to watch. Plus, it's been delayed 4 years because of her mostly. But let's see.
Is this something that I need to pursue continuously still for me to be able to receive my hard copies? Because no one tells me anything.
I cannot answer that question because that may call for me providing you legal advice, which I
can't do. Exactly.
Okay. Well, because I have no other way of contacting you other than in a letter, and it's AKA worldwide. So am I supposed to go back and speak to the captain and whoever else it is that I might need to speak to in order to receive these?
I cannot answer that question.
He just set out the procedure and how this stuff is going to get to you, how you're going to have when you're going to have access to the computers, where you're going to have access to everything. He just set that out.
All I can tell you is that we will have a hearing on August 5, whereby which Prison Break Investigations will provide all of the information on USB drives. Those will be provided to a representative from the Orange County Jail who will place all that information on a laptop for you to use, and that's accessible for your use from 0800 to 1600 every day.
Right.
Okay, so I guess I will figure that out, because if I'm up at 2 o'clock in the morning, I can't utilize the laptop, which is another reason why I was looking forward to the hard copies. So my other
see, that was kind of the argument I was making. I mentioned that earlier, that what if she wants to work after 4 p.m.? What if she can't sleep one night? But she also has to work within the strictures that are provided, the prison, the jail rules. She has to work in that framework as well. And I prefer, for the most part, it's kind of 50-50. Sometimes I want the papers to flip through and make notes on and things like that. Sometimes I'm happy with the electronic version, but she might have a minor issue. She's gonna have she's gonna have a few things that the appellate lawyer can at least make an argument about, and this might be one of them.
question is my time prorated for the time that I've been waiting for my discovery?
What?
I'm not sure I understand what that means.
Will I be having additional time added, or will it be extended from the time period of me waiting for my discovery still?
Oh, okay. So she's saying, are we going to, if it takes me 10 days to get discovery, are we going to bump the trial back 10 days? Okay. She's coming close to making a motion to delay the proceedings, but she's just asking right here.
I'm not in a position to answer that question. I don't know what it is that you're asking for.
I do, Judge.
The trial is supposedly set for September 24th, I believe it is. So obviously I will not be prepared. And obviously I do not know what I'm doing. And obviously I'm still waiting for my discovery.
Well, obviously you shouldn't have pissed off or got rid of your previous 8 lawyers. Your previous 8 lawyers. They would know what they're doing.
Discovery. So for that time period that I have been waiting for almost 4 weeks now, will that be added to the time frame in order for me to be properly prepared?
As of right now, the dates are what the dates are, ma'am.
Okay, so I just missed a week. A month.
The dates are what the dates are.
So I also sent you, I believe.
Okay, yep. She missed it by that much. That's and the judge is being a judge. He's not helping her by saying you should really make a motion. She just asked the question and he said, yeah, the dates are the dates. Her next thing should have been, well, I would I would like to, and I'll be filing a motion to, to delay the proceedings, to allow more time so that I can receive and review my discovery. But she stopped just short of that. Again, it could be argued by a decent appellate lawyer that that's what she was doing and he refused. But, as far as I know, she hasn't actually asked for additional time yet, though officially. So,
5 motions. Have you received those?
No, ma'am, I have not.
They were mailed last week.
Then I have not received them yet. The
Oh,
last
we got them.
correspondence I got from you, ma'am, was received on July 8th.
We've got them, and we're going to be looking at them here.
They're probably sitting wherever else it is, considering it takes a day for you all to receive my mail, considering I'm right down the street from you all. So I have those also in order, which may change whatever information or anything that I'm trying to acquire in between now, the month less that I have in order to prepare for my trial. That's in October. So if you could keep an eye out for those also. I don't know who I'm supposed to ask. How did Mr. Lane come into any of this? Like, how was he called?
Mr. Lane has been your investigator in this case, and he was advised to attend this morning's hearing by virtue of being provided the discovery in order to digitize it so that you can have access to it.
The court contacted him?
I did not contact him.
Am I allowed to speak to him directly?
Of course, he's your
can.
investigator. The judge is like, yeah, you can talk to him. He's your investigator. Yeah. Jay Liebga, what's up, Lieby? Don't worry, Jeff. She's watching to get your advice. There is no legal advice ever given here, Sarah, or anyone else that happens to be watching. We're just entertainers in this little old thing that we call YouTube. So there we go. Oh, and Tammy Fayette says, check Venmo. I will be happy to.
Mr. Lane, who contacted you in order for you to be here, please?
JA contacted me.
If I'm pro se and my own attorney, shouldn't I be included in all of this so I know what's going on and not a surprise hearing like it is again for the second time?
Ma'am, again, this is why there were benefits to being represented by counsel. The court has already identified in its 16-page order the reasons for why you no longer have those benefits.
Right. Which
It
is
makes
now
things
formed.
exceptionally more difficult, as I explained to you, in communicating with the court and communicating with the state attorney's office.
Isn't that what a certificate?
Tammy Fayette has just Venmoed $5. Thank you very much, Tammy Fayette. That's appreciated. I don't know if you wanted the ASMR, but you get it anyway. Thank you, Tammy Fayette.
Of services for anything that's filed by anybody in the court?
There
That
was,
should be included in that.
ma'am, there was no certificate of service for setting this for today. This was coordinated by the JA. You were advised as soon as it was set yesterday.
It's just very odd to me that the news knew about it before I did.
Again, I can't speak to that.
And so nonetheless, my
Stop
constitutional
it.
right to counsel is being forfeited on your behalf in the court. So now I don't get appropriate notice in preparation for me to be able to be here and doing what I'm supposed to be doing and act as. And
All right. This is the first indication that I'm going to probably have to double dose blood pressure pills watching this trial. She's already getting it because you forfeited my right. No, he didn't forfeit your right to counsel. He gave you 8 chances, which is more than I've ever heard anyone else getting. Shabusiness, I think, only got 3 lawyers, 3, maybe 4, 3. So, come on.
perform as?
I've already addressed the reasons, ma'am, for why there was a forfeiture and alternatively a waiver in the 16-page order that you were provided. Again, it's difficult to communicate with you based on where your current housing is. I'm not able to pick up the phone, the court, the judicial assistance.
Squid, have a great night. Thank you so much. Thank you so much for being here.
Not able to pick up the phone to communicate with you or send you an email to schedule certain things. And it leaves a little bit of a level of further complication.
How is it the news knows before I do?
You keep asking the same question and the answer is going to be the same. I cannot answer that question for you because I do not know.
Yeah, he's not in charge of the prison
It's
mail.
harder for me.
I would agree with that, yes.
And you do know that you did not ask me any questions in regards to your order. You just read it straight off and never asked me what's what or how many with anything of it.
Ma'am,
Ma'am, see, that's the nature of an order. It's not a Q&A. It's not a request. It's not an open discussion, Sarah. It's right there in the title, an order. In other words, the judge orders something to happen, and that's just the way it's going to be. So there you go.
if you have questions, I can certainly try to answer them. I'm trying to facilitate you getting that information that you're certainly entitled to. And it took time for a process to be created by the Orange County Jail. As they had advised me, they do not have a place to store 2 banker's boxes of information, nor are they in a position to provide you physical copies. This is what I've been advised as the process is. As soon as that process was finalized, I set the hearing. This was finalized yesterday.
No one ever asks me. I've been waiting for the boxes.
You ain't getting
Really
no
don't know what to
boxes.
say, and because I supposedly have no way to contact you other than a letter, and the same for you, I don't know how the news crews got here before I did.
They look at the court docket. It's right there online. That's how they know. They're probably monitoring it daily. But as for waiting for the boxes, she was the one that was complaining about, she doesn't trust anybody. She doesn't want people getting her documents or papers. They don't want people jumping on her case. She is the one that's making it so that she's not getting the paper documents. So, you can't have it both ways.
But I don't know going forward, how is it that I'm supposed to be able to communicate with you other than me sitting here in front of you at these, I guess, supposed surprise hearings that I'm going to have every single time that it is that you would like to speak to me? Is that?
Oh, okay, mommy. Look at this. She's like talking to the judge like it's one of her children. She doesn't have. She has one child, doesn't she? I seem to remember she has a son or something from her previous marriage. I could be wrong, but she's talking like a mother talking to a child. Yeah. I mean, just even her body position and her body language is like, I'm gonna reprimand you. I'm gonna make you go out and get your own little switch here, judge. Well, see, but Sarah, here's one thing. Do you know how everybody communicates with the court? Do you know how everybody talks to the judge? Through mail, email or snail mail, mostly email, but that's how, and it usually goes to the court clerk. You don't just say, hey, judge, what's up? It gets filed with the court clerk. The email goes to the court system. Everybody talks to the judge this way. You're in no worse of a position other than you have to handwrite it.
What it's going to be?
Ma'am, I cannot answer that question. All I can tell you is that you can communicate with the court through the avenues.
That's what I remembered.
Utilizing previously by and through letter writing. As I said, I do not have your letters that you sent last week. They're not in the court file, and they were not in my inbox yesterday. So as soon as I receive them, I will diligently review them. And if we have to set a hearing, you'll be properly noticed for it.
And the certificate of service.
You'll be properly noticed for it. Yes, ma'am.
And will there be a proper notice for today?
Notice was performed last night. I've already explained.
Ask the news crews how they got here?
No, ma'am, I'm not going to let you do that.
No.
They're not under oath. They're not a party to this action right now.
It's wrong and it's unfair.
Not really.
You certainly entitled to that opinion.
Am I allowed to ask him a question?
Sure, go ahead.
Mr. Lane, how is it that you and I are supposed to be speaking to one another?
What?
So
Oh, okay.
my suggestion would be, since you're now the attorney and you are pro se, that either you or your honor gives me access to the jail to come visit with you, and I'll be happy to do that. It is the policy of the Orange County Jail to have a letter representing from an attorney to allow me to access you. That's the reason for the past previous couple of attorneys I've not had the ability to come out and access you, but that's changed. And I would be happy to continue to move forward with.
Ms. Mandy reacts in chat. What's up, Ms. Mandy? I put in chat that I was going to redirect you earlier, and it was deleted, so I didn't write. Hey, don't worry about it. That's no problem. You're here, and that's the important part. Thank you, and welcome, and good to be here. Well, it's good for me to be here. It's good to have you here, Miss Mandy Reacts, everyone. A good big round of applause for Ms. Mandy Reacts. Woo. All right, thank you so much for being here. And yeah, now, Boosh, you say unfair, ma'am. You killed him. Allegedly, she is innocent unless she's proven guilty. It's kind of hard to say that with a straight face, but it's true. It's true. She's innocent unless she's proven guilty. Don't feel bad for the investigator, Rachel Ann. He's getting taxpayer money. He's getting paid for by the state. He gets paid for doing this.
Need a letter from me.
Or the judge or the jail, somebody that will allow me access to you. Yes, ma'am.
And I send it to you directly?
Yes, ma'am.
Is this a letter also that you'll be supplying to him?
I don't know that I'm in a position to compel the Orange County Jail to do anything.
But you are the ones who contacted him.
But I can't tell the jail, let this person come talk to you.
Yeah, that's not
If
what
they
they
have
do.
a policy where you need to provide the letter, then you need to provide the letter.
So until you have that letter, you and I will.
Oh my
not be able
God.
to speak with one another.
I will contact the jail myself and find out if there's intention for pro se, or maybe they can speak to you directly to circumvent the actual letter itself.
Thank you.
Ma'am, do you have any other questions?
I don't think you have enough time. I'm doing my best, and if you could please keep an eye out for my motions.
I will be on the lookout for them. You said there were 5, correct?
Yes.
I will
And if
be
you
on-
could please include me on the certificate of service for whatever hearings that we have that are no longer a surprise for me, please.
Understood. You'll be given a copy of the court's order that I read momentarily, and I will see you both on August 5 at 8:45 in the morning. All right. Thank you all very much. Mr. Cacciatore, anything further, sir?
Nothing from the state.
All right. Thank you very much.
That's a prosecutor
Thank you, sir.
Chicken
Have a good day.
Cacciatore.
Oh, wait, before you leave, that is all going to be yours. Yes, I would, sir, so that you can begin the digitization process. All right, I'll see you on the 5th. Perfect. Thank you, sir.
Those are some chunky glasses.
I'm just-
Just look at her. She's just like, are we done yet? That is the look of someone who thinks she's smarter, better, and more qualified than everyone else. Wow. All right. Well, I guess that's the end of the actual hearing. Well, I was trying to close the volume adjusted window. It's at 250%, but it says I can't access it right now. That's interesting. All right. Well, that's it. We'll be back for more Sarah Boone trial coverage. The hearing on Monday. The status hearing will be on Monday. But now let's look at these motions she was talking about. She sent 5 motions to the court. And we're going to be taking a peek at those. But before we do, what do we got going here? We got like a bunch of windows open. What the heck's all this? Ah, there it is. The volume. The volume. Now that I don't need it, the volume control was buried under about 47 pop-ups. All right. So here we sit. Deanna says she will accuse the investigator of not scanning all of her documents and ask for a new investigator. That, or he doesn't answer my phone calls. There will be some complaints, I'm pretty sure, and that would be the ones I would expect: not answering my phone calls, not giving me super special attention, and how do I know he's doing all of the documents? Legal advice, legal advices, says Bush, has been proven. Captain Crazy Pants over there admitted to it unintentionally. And John H. 2004 says, what do you think Sarah's defense will be? I didn't do it. Forgot. He got in there. He closed it. I fell asleep and I woke up and he was gone. I didn't do nothing. I didn't do nothing. We were playing the game and I fell asleep. I guess that would, that's the best I can think of for her. Oh dear. All right. Well, let's take a look at these motions. But here we are. We're at the 1 hour mark. So let's do a little midstream grifty thing here. We've got our like and subscribe poll. We've currently got almost 500 people here and only 289 likes. We need 200 more likes. Come on, people. You've been here. You're watching this. It's Sarah Boone. You got to like Sarah Boone. And also subscribe. We're going through the YouTube time of testing, where they're just saying, you don't need all these subscribers. We're just going to take big chunks of them every day. So we're going up, but they're deleting people faster. We've had, again, people that are just saying, I was unsubscribed. They do that. YouTube unsubscribes you. So please, if you have not subscribed to the channel, I would be deeply, deeply honored if you would do me the honor of subscribing to my channel. I would be indebted to you forever. Please hit that subscribe button. And if you are, for the reasons I just said, if you are already subscribed, just take a second and double check to make sure you're still subscribed. And then take our like and subscribe poll. Today's like and subscribe poll. So far, 7% of you say Sarah Boone should be an international human smuggler. 15% of you say Sarah Boone, best jailhouse lawyer. 26% of you say Sarah Boone, spokeswoman for Samsonite luggage. And 53% of you say Sarah Boone, just batshit crazy. And I do notice that we have 415 votes and only 313. 102 of you have cheated. You took the like and subscribe poll without liking and subscribing. And we are, looks like $7 away from unleashing the emotional support pig dog cam, the potato pig dog cam to be exact. Right. That's where we are. That's our midstream grift, the like, subscribe, and the update on the emotional support potato pig dog cam. That's our life. Let's get into these motions because they might be a little hard to read because Sarah Boone her writing is one of these really strange things where her handwriting is really good, but it's kind of weirdly good and illegible at the same time. Sometimes you have to squint and kind of twist your head a little bit to be able to read it, but her penmanship's quite nice. All right, let's bring on up the documents. Present screen. There we go. This is the order that was just given on July 25th, 2024. This is it in written form. The order, not the request, not the invitation for a discussion. This is the order. This cause having come before this court on July 25, 2024, and the court having reviewed the file and generally advised in the premises, it hereby finds, there's the magic court words, investigative services are being provided by Prison Break Investigations. B, the discovery that was provided to the court on June 28th needs to be scanned and placed onto USB jump drives in order for the defendant to access and review same while at the Orange County Jail. The court hereby orders and adjudges as follows. Prison Break Investigations by and through Investigator Billy Lane shall take possession and custody of the discovery that was provided to the court. So he's going to take custody of her discovery. And Prison Break Investigations by and through Investigator Billy Lane shall copy all of the discovery onto as many USB jump drives as necessary. The Judge Administration Commission for the State of Florida, the JAC, for the State of Florida shall be responsible for the fees and costs due to Prison Break Investigation copying all of the discovery onto as many USB jump drives as necessary. So Floridians, You're paying for this. Prison break investigations shall appear for a hearing on August 5, 2024 at 8:45. We could have just read this, didn't have to open up the court document. With all the discovery in the USB jump drive, blah, blah, blah. So, great. A representative from the Orange County Jail shall appear for a hearing on August 5. A prison break investigation shall hand deliver all USB jump drives containing the discovery to the representative from Orange County Jail in order to be placed onto a laptop that is currently secured and to be issued to the defendant for court/trial preparation, done and ordered in chambers at Orlando, Orange County, Florida, on this 25th day of July. And she's going to be served, hand delivered. It was probably given to her while she was sitting there in court. Yes, we don't want to save any changes. We just want to get rid of it. All right, here is the first motion. But before we do that, we've got to take care of some business. We'll call magic. Battery's housewife is her defense. Battered housewife. She was trying to do that, but she couldn't find an expert that would say she was a battered wife, which was kind of the problem. And I think it would be hard to argue self-defense when the victim ends up in a suitcase. We'll see what she does. Time will tell. Jen LG with the $10. Thank you so much. Dogs, says Jules, with the $10. Dogs. And Brissy Girl with a $5 Aussie super sticker. What's the super? Critical hit. Cool. It's a little game controller. Critical hit. And Just Dawn. Soulless Ginger with the $10. Release the emotional support potato pig doggos and keep the change. I will. Thank you very, very much for that. And Caroline B gave us the super sticker. The super sticker that is what? It's a little Shina Ibu dog with a heart. Oh, thank you so much. That's it. Ladies and gentlemen, we have reached the first goal. We have unleashed the hounds. And in all of their terror, in all of the emotional support, in all of the action-thrilled, action-packed doggo cam, here we are. There we go. Yoda's blasted asleep there. And Strawberry is over here. We will alternate between dogs as long as we have dogs to alternate between. Yoda's the most active here, as you can see. All right, there we go. We've got the dogs. And Lugmeister with the 20 Nokia monies. Thank you so much. Boone Defense. The suitcase ate him. The suitcase killed him. I didn't do it. Blame it on the suitcase. We've released the emotional support potato pig doggos. Little pigs. All right. It's time to get into her motions. Are we ready? Are you ready? So I did tell you she wins at least one of these motions. So Ferrets planted the suitcase. Yes, as we learned from the Florida v. Donald Hartung watch we did on Thursday, ferrets can't necessarily be ruled out of a lot of murder scenes. It could have been ferrets. All right. How much of this can we? How embiggened can we make this? All right, looks like that's as embiggened as we get. All right, deep breath, people. Oop, we've just got another notification. Oh, there you. Oh, two notifications. Oh, one is the email. The other is the other notification. What do we got here? This is. Come on, phone. Doot. Sorry, we're hang tight. For some reason, my phone is being really, really slow. All right, we are good. I heard an announcement. It's not saying where it's coming from, but I guess it's a mystery. Oh, Island sent $7. Woohoo! It says doggos, the taters. Thank you so much. Thank you so much for that. Sorry it took a while to get there. The phone is being oddly slow today. All righty. Thank you so much, Island, for the $7 for the taters. See what I mean by her handwriting? It's good handwriting, but it's really hard to read. She doesn't like her spacing is odd. 1997 Motorola phone. I think it just might be connected to the Wi-Fi hotspot across the house. Nope, it's connected to the one right here in the room. So whatever. I guess we'll never know why it's being slow today. But thank you so much, everybody that's using alternative payment methods. Why is she yelling? I used to write in all caps in college until one of my English professors said, stop doing that. So I stopped. In the circuit court of the Ninth Judicial Circuit in and for, or, oh, she started out with the official language. Why are you hyperventilating back there, Straubs? She's using the official language, so we're off to a good start. And we'll give you some strawberry time. She's using the official language. See, this is what I mean by she's not Brooks crazy. She might not be like situationally smart, but she's not dumb. So she's using right forms and things. But let's see how this goes. She's got the case number, the division, state of Sarah Boone defendant. Oh, geez. All right. Motion requesting intermediate relief. Let's read the other one first. This is the one that I scanned through. Same thing. She's got all the right stuff up there. Temporary motion for reservation of proposed cost to acquire investigator and defendant's defense trial. That's the title of her document. Comes now Sarah Boone. She's gonna use the magic language. Comes now Sarah Boone, pro se indigent defendant, respectfully requests from this court the reservation of proposed cost to acquire investigator for defendant's defense in trial. Ding, 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 ding. Wave some incense. There we go. She's used the magic court words, which is pretty good. Investigator to be determined. Total amount requesting to be determined. How to calculate unknown by defendant. Reason no discovery or case materials provided to defendant from the judge. This temporary motion is being submitted to meet the delegated due date of July 22nd, 24. Yeah, there was a pretrial motion deadline of July 22nd by the judge and court as stated to the defendant in the order dated 6/28/24. All right. The defendant is trying to avoid any further persecution. Well, you may not want to start out by saying the judge is persecuting you. That's not the best way to start your motion, but she's making a good effort here. She's trying to avoid any further persecution and penalization from the. You're going to be in prison. You might get penalized by some of the ladies there in your cells from your cellies. Sorry, saucy. From the judge and court while vigorously attempting to succeed in her forced position of pro se attorney and representation of self. Well, forced situation brought upon yourself, perchance. That might have something to do with it. Uncivil Law says, I'm not a fan of the comes now preface law. I hate it too. I hate the archaic stuff and even in Korea we do it. Every notary, every power of attorney begins with the comes now, and all that other stuff. Hey, phrasing. Hey, phrasing. The comes now, whatever party in the. I'm not a big fan of the formalization of the keeping the arcane words That's why we call it the magic court words. The defendant is trying to avoid further persecution. Well, that's good. The exceeded time limit of waiting to receive the defendant's discovery and case materials promised by the court has forced the submittal of this temporary motion. No, it's not a temporary motion. It's a motion. Once the defendant has finally received, she will be able to proceed. Oh, she's talking in third person. I'm really not a fan of talking in the third person, but Jules says the judge set 2 weeks for trial. I think it's going to be longer. Unfortunately, you're probably right. This should be like it was probably a 3-day trial or a 4-day trial, but the judge is going, oh God, I know this is going to take 2 weeks. That's what I'm thinking. I think this would probably be like a 3-day trial. He's just covering his bets. So again, she's not forced to do this. She created this situation. She ran off 8 lawyers. It'd be weird if she ran off her 9th one, seeing how it's her. Once the defendant finally receives this, I'll be able to do this, be able to proceed. We'll revise and resubmit. Oh, that's why she's saying it's a temporary motion. All right. She'll, after she gets her discovery, she'll submit the permanent motion. Well, whatever. We'll revise and resubmit this motion upon completion of her review and research of the contents. Wherefore, Sarah Boone, pro se, indigent defense. You don't have to put the indigent or the pro se part, but respectfully requests to the honorable court to reserve any and all costs proposed to be incurred to acquire investigator for and in the defense of her criminal case for trial. The defendant requests are in good faith. Well, that's good to know. And her merits are worthy. Oh, well, there you go. Her arguments have merit because she said so. In striving to successfully, lawfully, and properly perform, act, thrive, and overcome her forced by the court position of the pro se attorney and representation of self. Okay, that wasn't her best paragraph. And properly perform, act, thrive, and overcome. Let's all join hands. We shall overcome. That's Flux. If she was really, really sorry and promised to be a good girl and play well, could the judge give her one more? I think that train has left the station. I think that the train has left the station. Conclusion. This temporary motion for reservation of proposed costs to acquire investigator for defense in trial should be granted. So she wants an investigator to be appointed. Under the authority of Section 925-25 Florida statute and state. Oh, she's got a case site. Cool. Huh. It looks like a proper citation. It's been so long since I've had to do they call them blue book sites because there actually is like a citation blue book, and it used to be blue. It's probably not even a book anymore. It's probably just online. I don't even know if there's a hard copy of it, but it's I believe it's the New York Times puts out the blue book citation for like how to do things. I'm not sure who decided that somebody gets to tell everyone else how to do citations, but that looks like a. Kurt's here. Kurt can tell me if that looks like a good solid blue book citation to me. State v. Shearer. Looks good to me. All right. The defendant makes the following oath under penalties of perjury. I declare under penalty of perjury that I have read the foregoing document and the facts and matters stated in it are true. Oh, that's good. Good for her. See, she's not dumb. She knows what she's doing, and which is kind of part of the problem too. She might be just smart enough to get herself in much, much more trouble. So as I said, she's got a certificate of service on it. Cool. All right. Good for you. July 18th. Now, people, I told you, she wins one of her motions at least. That's the motion she won. She won that motion before she even filed it. She won the motion before the judge even got it. She's asking for an investigator to be appointed. She's asking for money for the investigator. Congratulations, Sarah. You just won your first motion before you made it. You get prison break investigations. She's off to a great start. She won her first motion before she even made it. So that's how good of a lawyer she is. Woo, Sarah. All right. Let's see how she does on the other one, shall we? But yes, she won her first motion as her own lawyer before she even. But see, that also causes you to wonder. Oh, wait a minute. Where did the dog go? It also makes you wonder. She filed the motion. The judge gave her the investigator, and she was still saying, I don't have an investigator. Why don't I get an investigator? He's like, dude, she's right there. He's right there. Come on. So yeah, a little bit of a disconnect. She didn't realize that she had this investigator, even though the judge told her she did. So all right, let's see what her second motion is, shall we? But you gotta be impressed with her. She won that first motion. So bing, 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 bing. There we go. Righto. Wait, why can't I do this? All right, here we go. Motion the second. Oh my God. Here's the comes now stuff. It's all on the same paper. Or she made she could have done all of this in one document. One document with 4 orders. We saw that with with Gingras and Woodnick in the Clayton Eckerd case, where the titles of the motions would be like this long because it says a bunch of stuff in there. She could have put all these in one motion, but that's just me nitpicking. She's got the spacing here. She's got the underlined spacing. Yeah, good. She's the pro se indigent defendant. Expert witness to be determined. Total amount requesting to be determined. How to calculate unknown by defendant. Reason no discovery or case materials provided to defendant from the judge. Now this has some legs to it too. We'll talk about this here in just a quick bit. This temporary motion is being submitted to meet the deadline. The defendant's trying to avoid any further persecution and penalization. It's the same wording she used with the other one. The exceeded time limit the exceeded time limit of waiting to receive the defendant's discovery and case materials promised by the court has forced the submittal of this temporary motion. We'll refile it once we get stuff. Okay, so she's asking for money to be set aside. She's asking for expert witnesses to be called and for money to be set aside to pay for the expert witnesses. This has legs. She's saying, hey, look, I need to call expert witnesses, but I don't know who they are because I haven't got my discovery yet. Now, see, this is good grounds for her to ask for an extension, for her to ask for the hearing to be delayed by at least a month, because so far it's more than a month. I guess it's been 5 weeks now. We're in our 5th week since the discovery was handed to the court. I should have had this discovery a month ago. I don't know who my expert. I don't know if I have experts. I don't know, and I haven't seen what's in the documents. And so I don't know who I can call as an expert. I don't even know if I have experts. Maybe there's already experts lined up by other lawyers. I don't know, and I need money for them. So I think this could have been a good basis for her to ask for a delay, but I haven't seen the request for an extension of the trial date. I think she's going to win this too, by the way, because she will get money for experts. Just how much, I don't know. The temporary motion is being submitted, and that's her second motion. Her certificate of Okay, her third motion. What is her third motion? Temporary motion for reservation of proposed costs to acquire all witnesses for defendant's defense in trial. I'm assuming it's going to be, well, you can't really be cut and paste, is it? It's a look and transcribe. Is that what it's the transcribe, not the copy and paste. Okay, respectfully request witnesses to be determined. Total amount requesting to be determined. How to calculate, unknown by defendant. Reason, no discovery or case materials provided to defendant from the judge. All right. Her ex will be state witness, right? Oh, I'm sure. I'm sure he's going to be on the witness list for the prosecution, because she called him immediately after. I think she called him long before she called the cops. I think because he showed up, I think, before the cops got there. But anyway, before this goes to trial, we'll review the body cam footages and the interviews relating to her. But her husband was on site with the cops, going, she's, that's Sarah. Temporary motions being submitted, trying to avoid further persecution. I had to file this because the deadline is here. I'll let you know more later. So I promise to be good. There you go. So, but now this is an interesting one. Money for witnesses to appear. Again, this is perfect grounds, as the way I see it, for an extension of the trial date, to get it bumped back a bit, because she doesn't know who she has to call for witnesses because she hasn't seen the evidence. She doesn't know who has said what in interviews. She doesn't know who has said what. If there's been any interviews of people, which we know there has been police interviews. She doesn't know if there's any. Just say the magic word, Sarah. Just ask for an extension and see. If she asks for an extension and he doesn't give it to her, the judge doesn't give it to her, that could be a solid ground for appeal. I think it's a very arguable point. It's as a potentially criminal was saying earlier. But I think she's got to ask. She's got to say the magic words first. Let's see. Her fourth motion. Where's the fourth motion? Why is this 20 pages? Temporary motion for deposition to be conducted per FRCP. It's got to be the Florida Rules of Criminal Procedure, not the Federal Rules of Civil Procedure. So we'll say the Florida Rules of Criminal Procedure, Rule 3.220 by defendant under pro se attorney, title and position ordered by the judge in court. All right, so she wants to depose everybody, which is again an argument. We got trial coming up. I got this a month late. I still haven't got it. I need to try to deposing people in a criminal case it's unusual. It's not really very common. You can interview them. You can talk to anybody. Say, hey, will you talk to me about the case? And they can tell you to shove off, and that's kind of the end of it. Motion for deposition. That's an interesting one. Comes now, Sarah Boone. Opponents. Oh, deponent. She's educated. Deponents to be determined. Scheduled dates for deposition to be determined. Total amount requested for completion. Weird. I had that conversation. No, it sounds like a conversation at a massage shop. What's the total amount you're requesting for completion? To be determined. Total amount requested for transcripts. How to calculate unknown by defendant. Reason defendant has been forced into the title and position of pro se attorney by the judge in court. See, I like how she types in all types. She writes in all caps, but when she's angry, she writes in bigger all caps. When she wants to emphasize her point, she writes in really big all caps. By the judge and court, pro se attorney requests to take depositions for her defense. My cousin Vinny. Well, see, my cousin Vinny is a good example of the this depositions for criminal trials not being the usual. But he went around and he talked to people and he asked them questions. You're allowed to do that and say, okay, well, okay, that's your opinion. Would you like to be a witness? Would you please come as a witness for us? My cousin Vinny asked her after expert testifies, Your Honor, I'd like a continuance to go over all this sheer stuff. Motion denied. Motion denied. And okay. No discovery or case materials have been provided to defendant by judge. Florida Rules of Criminal Procedure 3220 versus. Oh, she's quoting the law. Let's look at the law here. Discovery depositions. Okay. Oh, well, good for her. There's actually, well, generally, at any time after the filing of the charging document, any party may take the deposition upon oral examination of any person authorized by this rule. In any case, there's got to be more to it than that. At any time after the filing of the charging document, any party may take the deposition upon oral examination of any person authorized by this rule. Well, who's authorized by this rule? Tell us who's authorized by the rule, Sarah. You're supposed to say by this rule and under this rule, this sub clause, this is who is authorized, right? Well, she's like, in any case, no person. Oh, that's the law. This is in any case. She's even put in ellipses because she's skipped something. In any case, no person shall be deposed more than once, except by consent of the parties or by order of the court issued on good cause shown. A witness who refuses to obey a duly served subpoena may be adjudged in contempt of the court from which the subpoena issued. Tammy Fayette's leaving us. Goodbye, Tammy. Thank you so much for being here. A, the defendant may, without leave of the court, take the deposition of any witness listed by the prosecutor as a Category A witness. Well, what the hell is a Category A witness? Oh, is she going to tell us what a Category A witness is? After receipt by the defendant of the discovery exhibit, the defendant may, without leave of the court, take the deposition of any unlisted witness who may have information relevant to the offense charged. It's kind of broad. It's a pretty broad statute, Florida. All right. Ask for more time, Sarah. I want the trial to go ahead, but I want you to have a fair trial. If you don't ask for it, you don't get it. Ask for more time for this reason. Discovery sanctions. Oh, she wants some sanctions. If at any time during the course of the proceedings, it is brought to the attention of the court that a party has failed to comply with an applicable discovery rule or with an order issued pursuant to an applicable discovery rule, the court may order the parties to comply with the discovery or inspection of materials not previously disclosed or produced, grant a continuance, ask for a continuance. Sarah, ask. Sarah, ask for a continuance. And the judge says, shh. That was cold of me. That was really cold. Dang. Good heavens. What kind of a monster am I? Sarah, ask for a continuance. Grant a mistrial, prohibit the parties from calling a witness not disclosed. Oh, me. This shouldn't be funny, but it is. Right. Especially blame shifting. Out of curiosity, how many years is she facing? This is a second-degree murder. It's a good question. It's got to be around 30 years or so, I would imagine. Why have I never looked at what sort of prison sentence she's facing? Somebody in chat knows. Chat knows everything. That's what I love about. There's 500 people, basically 500 people watching here now. Somebody knows the answer. I love the hive mind. The hive mind is great. It's like any question you have about a case, somebody in chat is going to know it because we all have different pieces of information we recall. She's facing life for a second-degree murder. Okay, cool. Life. Don't talk to me about life. Wait here. Ask for a continuance. Evidence disclosed or enter other such order. What other? Or as it deems just under the circumstances. 2, willful violation by counsel or a party not represented by counsel of an applicable discovery rule. Now, see, this whole deal is like, oh, we can do all this stuff. Yeah, but you have to ask for it, Sarah. If you feel that this sanction rule has been violated, you have to ask for the continuance. You have to ask for the mistrial. It's not mistrial time yet, but you have to ask for these things if you want them. You can't just say you're not doing this. And Jules making the reminder, let's not forget that Jorge Torres Jr. family has been waiting for years to get justice. True. And don't forget, well, it's spelled Jorge Torres, but she pronounces it George. So we'll call him George. Willful violation by counsel. So, okay, what happens if counsel or someone else violates the applicable discovery rule? Shall subject counsel or the unrepresented party to appropriate sanctions by the court. The sanctions may include, but are not limited in content, or not limited to contempt proceedings against the attorney or unrepresented party, as well as the assessment of costs incurred by the opposing party when appropriate. Well, the opposing counsel, the state, the prosecutor, they did their job. They put the evidence there. It's just been sitting at the court for a month while we try to figure out how to get it to you with all of the restrictions you want on it. So the delay in discovery isn't on the prosecution. And what are you going to have the court hold itself in contempt? Probably not. The discovery motion, this discovery motion is being submitted to meet I had to submit it quickly because I didn't have time. Because I'm forced to represent myself. Once I get the discovery, I'll look at it and I'll revise this. All right, the defendant requests are in good faith. Conclusion, the temporary motion for allowance of deposition to be conducted for this rule for defendants under pro se title and position ordered to the judge and court for her defense shall be granted. See, she didn't ask for any sanctions. She didn't ask anybody to not do what she would have got it, but she didn't ask for it. She just throws these things out. Throw it out. Don't just throw it out there. Ask questions. All right. Why am I frustrated with her? A certificate of service and the envelope. Here's the mailing address if anybody wants to send her love letters. That's kind of illegible. Well, that is the first motion, and she already won the first one. Good for her. She won the first motion. The other two, she'll get money for expert witnesses. As to who her expert witnesses, shifting dogs, as to who her experts will be, she's got to find one first. But if she can find an expert, she'll get a little bit of cash for them. Discovery, she's got it. They just have to get it to her by August 5th on the thumb drives. So she's not doing too bad with her motions. She's won one. She's gonna get another one. And the witnesses, the depositions, not so sure about. But we'll just have to see. Righty. Oh, before I do that, I want to do the response to her. There is a response from the from the Justice Administration Commission. This is the response to her motion seeking due process costs. So the state has submitted their response to her request for money for these things. Dorothy, are you going to be standby counsel? That's the next motion. We'll get there in a minute. But no. Yeah. Yoda just came back in the room. Yoda's sitting like Snoopy on top of his doghouse. He's just like hanging out there. I have to back the camera off a bit here to get some Yoda action. Oh, okay. You better just lay down, dog. Do not do what you do. Yoda, I'm watching you. Good dog. Just flop down there. There you go. Stupid dog. All right, so let's look at the response to the costs motion. Can we make this? I wonder if I can make. Yoda, you make me nervous. There was a strange doggy. He made me nervous. He took me in and gave me breakfast. All right. Justice Administrative Commission's response to motion seeking due process costs. Jeff, your dog fell over. Yeah, Yoda just kind of falls over. It makes me laugh every time Yoda lays down. Comes now. Hey, phrasing.
Phrasing.
I hate this. I really do. I'm with Kurt on this. I hate this comes now stuff. But we've got to have the magic language, don't we? Comes now the Justice Administrative Commission, JAC, by and through the undersigned attorney files its response to the above cited motions as follows. Ding, 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 ding. Incense. The defendant is seeking authorization for various due process costs, such as appointment of standby counsel. Okay, we guess we should read the motion for standby counsel first, but we won't. We'll read the order here first. Cost to take depositions, an unspecified amount for a defense investigator, and specified expert witnesses to assist the defense, costs for unspecified witnesses to appear at trial. Jacob's Proud Madre, welcome. Hey, chat. Hey, Jeff, it's great to see you. It's always great to see you, Jacob's Proud Madre. And as an initial concern, any future requests for due process costs, such as requests for transcript, investigative costs, or experts, need to be served on JAC prior to the court considering the matter. They're like, yeah. Before you ask the court, ask us. So they're saying, Sarah, don't surprise us. Don't have these surprise requests. We want to hear about it first before you tell the judge about it. The defendant is responsible for providing JAC with any motions for due process costs so the JAC can respond accordingly to those requests. So in a hearing where she was complaining about being surprised and railroaded, she's surprised and railroaded the state. JAC may only pay for due process costs pursuant to section 29.0.007, the James Bond clause, Florida statutes, as directed by 27425 Florida statutes and the General Appropriations Act. All due process services are subject to the Florida statutes and the JAC contract, policies, and procedures. JAC objects to any compensation rate in excess of established rates. Okay, so they've got a limit on their rates that they are allowed to give. Standby counsel. For the appointment of this is the long motion here for standby counsel. We'll get to that after this. As for the appointment of standby counsel, the court entered an order on June 28th. Oh, well, spoiler alert. I was going to say she probably doesn't get it, but spoiler alert. The defendant waived her right to court-appointed counsel through her conduct in this matter. Thus, the court has already ruled on the issue of appointed counsel. Deposition-related costs. As for costs to take deposition, the defendant is authorized to incur costs to take depositions for those depositions authorized under the Florida Rules of Criminal Procedure. The notice and taking deposition substitutes for a court order. The notice of taking deposition substitutes for a court order for purposes of the court reporter seeking compensation for appearance fees. As for service of process, service must be through the sheriff unless the sheriff is unable or unavailable to provide service of process. In those instances where private service of process is necessary, a separate motion to incur costs for private process server will be required. The sheriff must be used to serve in-county law enforcement. As for transcripts, JAC has no objection to regular paid rates. The motion and order for transcripts must reflect sufficient information to identify the proceedings to be transcribed, such as the type and date of hearing, date and type of hearing. Proofread, people. Proofread the type and date of hearing, the date and type of hearing. Kind of, it's a little redundant there. And recording type and date of recording. The defendant should only order those transcripts necessary for the defense of the case. The uniform state rates are set forth in the General Appropriations Act. Private investigator costs, which she won. Woohoo! She won the motion. Pursuant to the uniform statewide rates, the rate for investigators cannot exceed $50 an hour. So prison break investigations are going to get $50 an hour. But that's not an unlimited resource there either. As required by Florida law, any private investigator providing services must have a Class C license from the Department of Agriculture. The Department of Agriculture and Consumer Services. All right. And be employed by an investigation agency with a Class A license. If the court grants the motion, which is essentially done before she got the motion, the order needs to indicate the amount authorized for the defense investigator. Based on the docket, it appears prison break investigations may have already been appointed to this matter. Yup. JAC does not object to the court authorizing $5,000. So that gets her, as for defense investigator, and $500 for the investigator to obtain case-related documents. So she gets $5,500. And that's good for 100 hours. Then if she needs more than the $5,000, if they burn through the $5,000, then she gets to make another motion requesting more money. Expert costs. Based on JAC records, the court previously approved $3,000 at a rate of $200 per hour for defense mental health expert. JAC does not object to the court continuing this authorization now that defendant is representing herself. As to the other requests for other experts, defendant will need to file an appropriate motion delineating the following: identity and type of expert, amount authorized, cap for the expert services, and the rates authorized for the expert services. The defendant has the burden to show the particularized need for each of the expert witnesses. The defendant needs to show the services of the expert is necessary for the defense of the case. Any party seeking due process costs has the burden to establish the particular, okay, that's what we just read. A prejudice arising from the denial of the due process service. I have to show that too. She'd be prejudiced by not getting it. The determination of whether to appoint an expert is within the broad discretion of the trial court. An indigent defendant must show the trial court that there exists a reasonable probability both that the expert would be of assistance to the defense and that the denial of expert assistance would result in a fundamentally unfair trial. Cost for ordinary witnesses, they'll need to submit a more detailed motion delineating the witnesses she seeks to summon for trial and the anticipated costs. Requirement for JC due process contract. Okay, this is just like payment stuff. The court should grant the defendant's motions, also include in its orders the specific due process certificate of service. So the state's going to give her money. They're going to give her the money she wants. She just needs to be specific about a lot of things. Dorothy asks, what is OF OnlyFans? The naughty website. All right, let's see here. How did we get on OnlyFans? How is that? How did we get on Runkle and OnlyFans? What is going on in chat? Oh, Runkle was banned from OnlyFans because he was showing weaponry. Hey. Phrasing. Righty. That's interesting. Of all the things that you can show and do on OnlyFans, and it was showing a weapon that got him banned. That's wild. Who would have thunk? All right. Let's look at this standby counsel. How are we doing on time here? We know how it's going to end. This is a 29-page motion where we won't be reading this whole 29 pages. We'll look at the meat of it, so to speak. We'll look at the meat. Oh, dear. Runkle was going to name his adult film Comes Now. Oh, Jesus. Ian, I like the way you think. Okay, folks, the final motion. Motion requesting immediate relief to the defendant by appointing effective standby counsel to aid and support in preparation of the criminal case for trial. Comes now. Dang it. Requests from the court immediate relief by providing effective standby counsel with all legal services allowed and included to assist and aid the defendant as a whole in the complete vital procedural preparation with professional guidance during her forfeited right to counsel by the court as pro se attorney and her proposed lawful representation of self in her criminal case. Forfeited. Defendant's justifiable reasons for request for relief are as follows. Okay, here's the reasons why she needs a standby counsel. And I was going to say she's not going to get it, but we know she doesn't get it. Because essentially, what a standby counsel is a court-appointed attorney. For someone who can't afford a lawyer and for some reason doesn't want a public defender, the court will essentially appoint someone to literally stand by, sit next to you at counsel table, give you ideas, give you help you out when you need it, and help you with filing and things. It's essentially having a court-appointed lawyer. And I'm pretty sure, without seeing the judge's order denying this, it was probably you already had 8 of them. You had 8 lawyers. We're not going to give you a 9th. You've burned all the bridges. You've burned all the bridges. You don't have a right, I believe, to a standby counsel. You have a right to represent yourself. You have a right to an attorney. Pick one or the other. I don't think you have a right to a standby counsel. It would be interesting if you do in Florida, which I doubt because the judge says no. Good luck, Sarah, says Flux. Good luck. Okay, PayPal. The dogs are snoring away. The defendant's 6th constitutional right to counsel is being violated, unlawfully withheld, and forcibly removed from the indigent defendant under false pretenses, speculation, libel, and misconstruction. I doubt it. I doubt it. You had 8 counsels appointed, Sarah. Your constitutional right to having a lawyer was granted 8 times. 8. It's not an unlimited source. 8. So yeah, no. I would say no. You had 8 chances to get along with your lawyer. You were told you ain't getting another one, so suck it up and get along with your lawyers. She couldn't do that. By the defendant's lawful practice of her entitled first constitutional right of free speech and her God-given right to do so by writing her experience-derived truth and providing red flag exposure in her correspondence. This is the Sarah Boone we know and love. Those 4 motions we read, those were all well written. Probably she got some sort of form somewhere in jail and just kind of did it well and did it rationally and did it reasonably. This is free form Sarah. This is Sarah freestyle in her motion. She's freestyling here. AKA the cat lady. Jeff, did you hear Sean, potentially criminal, is the lawyer for Lynette and Crook? Yes, I heard that on Megan and Tug's show. I did hear that. Where did we? Thank you so much, AKA the cat lady. Now, where was I? Oh, yes, the red flag exposure in her correspondence to the court requesting needed intervention to avoid present circumstances. She has lost completely her ability and advantage to properly, rightfully, successfully prepare her defense of innocence, progressively advance fairly and unrestricted while having the ability to be leveled equally with the prosecution. No, you had 8 chances, ma'am. You really did have 8 chances. and you squandered them. Yeah, that's you can get technicals. You have a right to have a lawyer represent you. If you cannot afford one will be appointed. she's had all the lawyers. At some point, you're going to run out of public defenders. The defense is not an officer of this court. You kind of sort of are now. You're going to be treated like one, or any court or legal system as a whole. She is not bound lawfully under oath or certified in any professional manner to be or act as a legal agent or representative. Lacking requisite professional competency, but she is good with her hyphenated line changing words. Experience, expertise in the field of law presently and historically. That's why, Sarah, you got to get along with your lawyers. That's why you have to make do with what you're given by the court, whether you have agreements or disagreements with them, because you just might lose whatever little bit of help you had. Can't say as I feel particularly sad about this. Island with the $5 says, it's my fault. Sorry, I derailed chat. Please forgive me. I'll shut up now. Never shut up, Island. Never shut up. The defendant is defective. You said it, Sarah. I didn't. The defendant is defective. I don't know why I found that was funny. Oh, I just got a national alert from the government. It's a heat warning. It's expected to be 100 degrees today, between 35 and 37 degrees Fahrenheit. Avoid outdoor activities if possible. Drink lots of water. Thank you, government. Appreciate that. The defendant is defective and ineffective counsel to self as a result. Well, think about it before you do the dumb stuff. Ms. K. Griff says 101 here today. 100 degrees is really hot here in Korea, because it always comes with like 60, 70, 80% humidity in the summer. It's just oppressive. Oh, hell. Which therefore will detrimentally impact and impede favorable justice to the defendant and the opportunity of a fair trial based on equality with an unprejudiced conclusion of her case. 3, the defendant is presently incarcerated, which is causing and will cause unfair burdens. That's kind of how it works. Sorry. Which is causing or will cause unfair burdens, limitations, deprivations, inaccessibilities, and unequal opportunities in and to her ability to complete tasks and timely responsibilities suitable to the vital defense of the defendant's life and livelihood futuristically. And that's one of the reasons why they give you lawyers. That's one of the reasons why people get court-appointed lawyers. But you can also lose. You can also lose that. You can waive it by your behavior. There you go. Wim says, Legal Vices, I'm near Ms. K. Grift. It's still above 80 and 9 p.m. Yeah, it's the sticky part of summer here. By the court rejecting professional, educated, experienced aid and assistance of effective standby counsel to and for defendant in preparation and production of her rightful defense, results may be adverse from the unfair, disadvantaged, oppressed circumstances to properly thrive in her forced position by the court of pro se attorney and representation of self. Examples of we get some examples of unfair burden. Cool. Examples of said unfair burdens, limitations, deprivations, inaccessibilities, and unequal opportunities include the defendant has not received from the court to date of this motion any of her promised discovery. That is a fair argument. That is a good argument. She has not been giving her discovery because it's taken a month for them to figure out how the hell to get it to her. That's a solid argument. But that's already passed. Any of the promised discovery or case-related material submitted by her former attorney to the court during the unannounced hearing on 6th, it was announced, with only 4 days to submit my demand and motions delegated by the court on or before 7/2022, 7/22/24. Defendant has not received from the court to date of this motion any of her promised discovery or case-related materials submitted by. She just said that. That is. A and B are literally exactly the same paragraph. She's copying and pasting this from somewhere. And I mean, transcribing it. It can't be copy and paste. So yeah, A and B are exactly the same paragraph. I mean, with the same line breaks and everything, like the dis-covery. It's like literally exactly the same. So, huh? Oh, come on. This is the same too. And see, they're different stars, and it's like it's not somehow a glitch in the scanning system. It's different writing, but it's this. Come on, Sarah. Maybe she did it on purpose. The defendant does not have access to a computer. Well, you do now because the court just gave you one. The defendant does not have access to the internet. She'll have access to some sort of probably online or some sort of database somewhere. The defendant has extremely limited irregular access to basic tablets supplied by the OCCD. Well, you have a computer now. You can use from 8 to 4 p.m. every day. Defendant has access to pay phones. Why is that in parentheses? I mean, in quotation marks. It's a payphone. For collect calls only, limited to 15 minutes each call. Because you're in jail. That's why. Defendant does not have access to organizational supplies or production equipment, copier, printer, etc. Defendant does not have access to a meeting place for privacy in case review preparation. You're in jail. They don't like leaving you alone in private rooms when you're in jail. They kind of like to keep an eye on you. Additionally, daily obstructions and undetermined hardships, disadvantages, difficulties will likely come about due to being incarcerated. Yeah, that's kind of what incarceration does. And once my case materials are finally received, continued application in reasoning and further lawful support of defendant's request for immediate relief with standby counsel to aid. Oh, she's telling us that she's going back to her motion. She's done with her examples. Now she's going to go back to the main body of the motion. Oh, Mandy, you're going to be at the hearing on Monday. Cool. Probably won't be epic, but it'll be cool. Let us know how it goes. That should be fun. In all criminal prosecutions, the accused shall enjoy the right to a speedy and public trial by an impartial jury of the state and district wherein the crime shall have been committed, which district shall have been previously ascertained by law. Okay, she's quoting from something here. And to be informed of the nature and cause of the accusation, to be confronted with witnesses against him, to have compulsory process. Yep. That's not what this is. I see what she did. But anyway, that's the Sixth Amendment. There you go. Oh, right to counsel from the Bouvier Law, the Bouvier Law Dictionary. Okay, see, I would. There's something we can do We can start a letter writing campaign to give her Black's Law Dictionary. Rather, I've never heard of Bouvier Law Dictionary, let alone a 14-year-old edition of Bouvier Law Dictionary. What does that say? The right to counsel is assured by the 6th Amendment, which has been incorporated into the Due Process Clause of the 14th Amendment. Thank you, dictionary, as well as the state constitutions, so that every criminal defendant who faces a potential loss of liberty has access to an attorney who provides effective assistance of counsel at each stage of the criminal proceedings and process. Right to counsel applies whether the defendant can afford to hire a lawyer or not, in which case the court will appoint without charge to defendant. Well, yes, she was appointed counsel. She was not appointed counsel once. She was not appointed counsel twice. She was, in fact, appointed counsel 8 times until the judge says, aha, I know what we can do. I know we'll appoint a lawyer. We'll appoint a lawyer that you can't fire. You're your lawyer. And she's good enough that she quoted the 6th Amendment here. So good for her. She quoted it. I'm seeing I'm double checking to see if she left anything out. No, she's even got the semicolon in the right place. So good for her. She's got all the semicolons. All right. Yep. Yeah. All right. I was just double checking there to see if she added or left anything out. She didn't. Good on her. Right. A waiver of counsel is a criminal defendant's refusal of counsel at any stage in the criminal process. I have never refused. Well, see, there's a refusal by verbally, either orally or in writing, and there's also the refusal by action. One could argue that she refused her right to counsel through her actions. Bouvier just reminds me of that big black herding breed that looks like Schnauzer and a poodle with a funky haircut and massive bangs. Oh, the one looks like it has like dreadlocks. But now Bouvier is reminded that's like Marge Simpson's maiden name. That's all I think about now when I hear Bouvier is the Simpsons. Waiver of counsel is I've never refused except by action, one could argue. It is made by a person with full capacity, unprepared, that is knowingly and voluntarily forced, and that clearly and unequivocally rejects representation or assistance by an attorney at law during the pending proceeding. Waiver of counsel, Bouvier Law Dictionary, 2012. A defendant's decision to waive their right to counsel must not only be competent, but also knowing and voluntary. Says Maynard v. Boone. Oh, how interesting is that? She's citing a case that also involves Boone. A federal case even. How ironic. Can's Counseling Couch says, legal question. If she refused orally, does she have to refuse anally, or is that waived? That's, one refusal is enough. Doesn't it's preferable if it comes from the mouth. But yeah, we're not gonna, we're just gonna move along here. We all don't mind. Let's embiggen this a little bit more so you can suffer along with me in full. There we go. Yes, Jacqueline Kennedy was a Bouvier, which is why the Simpsons named Marge after. That's why they named Marge Bouvier. It was after Jacqueline Kennedy. Fun Simpsons facts. The right to waive counsel forced by the court is the right knowingly to proceed in ignorance. Sarah, you are going to proceed in ignorance. It is sufficient for purposes of both the state and federal constitution that the record, taken in its entirety, shows that the defendant comprehends that a waiver of counsel means they will proceed into the labyrinth of the law without. Ooh, I like that. I like that phrasing. Proceed into the labyrinth of the law without assistance of a trained guide. I like that. That's good wording. They will proceed into the labyrinth of the law without the assistance of a trained guide. That's good. And I didn't see the last hearing where he said you're on your own, but I'm willing to bet that at some point he said something along the lines of, you do realize if I let this lawyer walk, you ain't getting another one. You got to decide, are you going to get along? I'm assuming he said something very much like that. In other words, gave her the indication that you play ball or you enter into the labyrinth of the law without the assistance of a trained guide. Oh no, stay with us, Jeff. What have I done? What happened? Why? Where am I going? I'm not going anywhere. What are you talking about, Flux? What are you talking about? I'm not going anywhere. The court must first make inquiry into his competence and be reasonably satisfied of it before accepting the accused waiver of counsel. Never gave. Competence means more than a minimum of mental awareness and capability. However, and involves an intelligent conception of the consequences of his act. No one explained it to me. Holy crap. Whoa. Holy cow. Corey Boatwright. That's insane. We need to get the big foghorn here. Corey Boatwright just gifted 50 Legal Vices memberships. That's crazy, dude. Thanks. That's all I got. I'm kind of was not expecting that. Wow. Wow. Thanks. Kind of took me by surprise there. Everybody get like 10% of you, more than 10% of you get memberships gifted to you right now because Corey Boatwright is an absolute monster in a good way, a good kind of monster. Thank you very, very, very much. You do good work now. Thank you. Thank you for that. That was shock and horror. That's what I mean. It was the shock and horror of it all. I was unprepared. And for those of you, yeah, let's see those member emojis. We've got our membership emojis for all of you, the new channel members. We've got a few Legal Vices. We've got 2 cowboys. We've got a ship's captain. We've got me with a tinfoil hat. We have unbreaded. We have a strawberry one. We have me with a drink in my official Johnny Depp Mega Pint Pimp Daddy Legal Vices cup. We've got Yoda. We have me with a crown. We have a Lorax. We have money. We have Taylor Business's head in a bucket. And we have the one that was designed by Flux and I, the retarded pussy frog. Because some people just are. Some people just are retarded pussy frogs. All right. Thank you so much, Corey. Corey Boatwright, ladies and gentlemen, gets the boat foghorn again. Thank you so much. All right, the pussy frogs are rolling. See, this is how a lot of things on this channel, and I'm sure other channels, are born. There was some fighting. There was some infighting going on in chat one day. I can't even remember what chat was fighting about, but chat was fighting amongst themselves, and Flux stepped in and said, "Everybody, just stop being a retarded pussy frog." And thus the emoji was born over the next couple of days. So it's Flux's fault. All right. Wow. Again, let's get back into this. Yeah, seriously, Libby, boat ride, making it rain. Making it rain. And we will be doing a members only stream next week, because we got things to discuss for the upcoming F Friday, which will be probably about 3 weeks. But it will be an alcohol-free F Friday. So we got to discuss. We'll leave it up to the members. So we're gonna have a bunch more members that can join and do that. So all right, that's super awesome. Let's get back into this. The court must. I can't even remember where the hell we were. Okay, competence reading. Okay, no one explained it to me. The trial was a farce or a mockery of justice, or was shocking to the conscience. Oh, that's legal words there. That's the shocking of the conscience. Yeah, that's also legal magic words. Those are some. Those are ranked right up there with comes now the shocking of the conscience of the reviewing court, which is basically whatever decision it is has to be so bad that the judge looks at it and goes, "Oh, my conscience is shocked by what this other court did," or things like that, or "Oh my God, this verdict! My conscience is shocked by what the jury came to this, how the jury came to this conclusion." That's a legal standard. I don't think it's. I think they've moved on to a different standard than just shocking the conscience of the judge, or the purported representation was only perfunctory, in bad faith, a sham, a pretense, or without adequate opportunity for conference and preparation. People v. de Graffenifnerd. It's a Michigan case from 1969. Hey, year I was born. It's a Michigan case, not a Florida case. She's citing a different jurisdiction's case, which I would hazard a guess that perhaps there was a case cited in the Bouvier Law Dictionary. They probably mentioned this case with this quote, and she just stuck it in there because it's not a Florida case; it's a Michigan case. But that having been said, if I'm going to be in jail for the rest of my life as a punishment, if I get convicted, I'm going to be using every state's case citation that I possibly can. So I can't fault her for using it, but in-state is way, 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 way better than out-of-state cases. But hey, do what you got to do to keep yourself out of jail. Ineffective counsel is both a standard inadequate performance for a lawyer in a criminal representation and a failure of due process of law to the criminal defendant, a person who has suffered a punishment in a criminal proceeding. I was repeatedly lied about by former attorneys to the judge. Yeah, see, there we go. There's 10 people in a room and 9 of them are assholes. Yep, everybody's an asshole but me usually means I'm the asshole. I was repeatedly lied about by former attorneys to the judge, who is unjustly believing all of them over me. Why are you believing all of the lawyers over me? She's not reading between the lines very well. She's not seeing the irony in these words. She's not. All right, falsely accusing me of an inappropriate and wrong, quote, strategy of removing attorneys who withdraw from my requests to the court for intervention, causing me to be forced into losing my right to counsel from their ineffective counsel. Yeah, I'm going to say that all of the lawyers you appointed were very effective. But see, this is the crux. She's saying it's her strategy. Yeah, it's pretty clear, at least to me, that this is an orchestrated strategy to delay this proceeding. I could get it if she was a free woman, but if she's already in jail, get it over with. If you're going to be there, be there. Yeah. Let's see. To which there is a right to counsel, but who received ineffective assistance is ordinarily entitled. How many? She's got like 1, 2, 3, 4, 5, 6. 7, 8. She's got 8 hyphenated words in one paragraph. How many of you just go, if you know you're not going to have enough room at the end of the line, how many of you just start the word on a new line? I'm trying to think if I have ever in handwritten documents hyphenated a word, as a line break. And inadequate, this QUATE could have fit up there. I just don't think I've ever used a line break hyphen in a written document. All right. Who received ineffective assistance is ordinarily entitled to a new proceeding with adequate representation as long as there is a reasonable probability that the result might have been different if the person had received adequate legal assistance. Yeah, see, this is the deal. This kind of is the crux here too. Say you've been denied your right to counsel for whatever, and it goes to appeal. As long as there is a reasonable probability that the result would have been different. I'm going to say this is one of these cases where it wouldn't make much of a difference if she had a lawyer or didn't. The outcome is pretty much going to be the same. Ineffective assistance of counsel, Bouvier Law, 2012. Due to ineffective assistance of counsel, the federal courts in 1999 set this second sentencing aside. Well, that's a very, very unhelpful case. Florida Constitution. We get to see the Florida Constitution. Basic rights. All natural persons, female and male alike, are equal before the law and have inalienable rights, among which are the right to enjoy and defend life and liberty and to pursue happiness. Ooh, that's almost like something you would see in, a constitution of the United States or something. Freedom of speech and press. Every person may speak, write, and publish sentiments on all subjects, but shall be responsible for the abuse of that right. No law shall be passed to restrain or abridge the liberty. Okay, free speech. We don't need to read all of the. There's a lot of free speech here. In all criminal prosecutions and civil actions for defamation, the truth may be given in evidence if the matter charged is what? Okay. It is true and was published with good motives. The defendant writing truthful, lawful letters to the court requesting help with dysfunctions of attorneys. She has dysfunctional attorneys. She does now. Then the defendant is unlawfully forced to forfeit her right to counsel from lies, misrepresentations, and ineffectiveness from those former attorneys, retaliation from the court. Yet, again, you don't win friends by telling judges they're persecuting you and they're retaliating against you. The party defendant shall be exonerated or given appointed counsel. The right to assemble. They have the right to peaceably assemble. Okay. To instruct their representatives and to petition for redress of any grievances. This representative is likely, almost certainly referring to your like government representatives. Due process. No person shall be deprived of life, liberty, or property unless it's a government seizure for, property seizures. We hate those because that's no due process there. Anyway, this has nothing to do with this case. No person shall be deprived of life, liberty, or property without due process of law or be twice put in jeopardy of the same offense. Ooh, that sounds very constitutional. Section 16, rights of the accused. All criminal prosecutions, the accused shall upon demand be informed of the nature and cause of action. Yes, you have been identified. And shall have the right to have compulsory process for witnesses, to confront at trial adverse witnesses. You'll get that chance if we ever get to trial, to be heard in person by counsel. You are heard in person. You won't be by counsel anymore. It will be in person moving forward, and have a speedy and public trial by impartial jury in the county where the crime was committed. Access to courts. Every person has, that's right, you get that. The 14th Amendment of the Federal Constitution declares all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and the state wherein they reside. Yeah, that's an interesting thing. That's kind of a cool thing. It's a little Easter egg in the Constitution. The federal Constitution makes you a citizen of the state you're in. So he's like, hey, How do I know? How do I know I'm a citizen of Florida? The Constitution says you are. Because you reside in Florida. Therefore, you are a citizen of Florida. No state shall make or enforce any laws which shall abridge the privileges. Okay, you get life, liberty. Basically, here you're not going to deprive of life, liberty, property without due process. Pretty much exactly quoted in the Florida Constitution. This provision This provision has often been construed by the United States Supreme Court, and it has been uniformly held that, quote, due process of law requires ample notice to the accused and sufficient time to secure counsel and prepare for trial. Yeah, you secured counsel about 8 years ago. It's only been 4, but it seems like 8. I meant to say 4 years ago. You've secured the right to 8 counsel since then. Just they ain't gonna give you a 9th. A like rule as to necessity for due notice and a reasonable opportunity to prepare for a defense is declared in Franklin v. State of South Carolina and a bunch of other cases. All right, so she wants this. We're going to skip through most of this because she's just quoting cases, more cases. Commonwealth v. O'Keefe. Sad to see Commonwealth and O'Keefe in the same line there, isn't it? Rip John. Free Karen Reed. Justice for Karen, all that other stuff. Okay, more quoting. The hate of the mob. An affirmation of the right to the aid of counsel in petty offense. Okay. Recognizing the rule was settled at common law. Denouncing. Okay, she's still quoting shit. The inviolable character of the confessional. Article 5. All criminals shall have the same privileges or witnesses as counselors. This is good. This is just all quotation stuff here. Even the intelligent and educated layman has small and sometimes no skill in the science of law. Think about that before you do dumb shit that gets your 8 lawyers to either be removed or remove themselves from your case. He is unfamiliar with the rules of evidence. Left without the aid of counsel, he may be put on trial and convicted upon incompetent evidence or evidence irrelevant to the issue or otherwise inadmissible. He lacks both the skill and knowledge adequately to prepare his defense, even though he have a perfect one. He requires the guiding hand of counsel at every step in the proceedings against him. Without it, though he may not be guilty, he faces the danger of conviction because he does not know how to establish his innocence. This sounds very Clarence Darrow-y. I wonder who wrote this. If that be true of men of intelligence, how much more true is it of the ignorant? In any case, civil or criminal, a state or federal court were to arbitrarily to refuse to hear a party by counsel, it reasonably may not be doubted that such a refusal would be a denial of a hearing and therefore of due process. In the constitutional sense, the decisions all point to that conclusion. Who wrote this? Oh, lengthy stuff. The necessity of counsel was so vital and inoperative in the what are we reading from? Oh God, we are reading from something. This is a compare. I don't know where that came from, but that was very well written. Whoever wrote that, Hendricks v. State. Oh come on. She wants to stand by you notice how there hasn't really been much mention of a standby of her right to have a standby counsel appointed because there isn't one. This is all her asking for some help. She had help 8 times. Federal rules of criminal procedure. Crack my knuckle. My finger is getting tired from scrolling. Wait, I've been abandoned by the dogs. They've both left. Oh, all right. If they come back, we'll do that there. Gideon v. Wainwright. Was that from Gideon v. Wainwright? There you go. There you go. See, I'm smart. Which is the Inherit the Wind, the Gideon Wainwright movies. They're like Gideon's Trumpet, I think was another one. Great movies. Gideon v. Wainwright. I knew it sounded good. Excuse me 1 second here. Which is it's a very, very important case in the right to counsel. I just didn't recognize the wording because last time I saw it was about 30 years ago. But bring up the Gideon v. Wainwright decision here. So we can kind of talk you. Any Fifth and Sixth Amendments. I'm just kind of reading to see if they're like the important part. That was the important part, actually. Huh. All right, but anyway, that was we'll just read you the wiki version here. Gideon v. Wainwright from 1963 was a landmark U.S. Supreme Court decision in which the court ruled that the Sixth Amendment of the United States Constitution requires U.S. states to provide attorneys to criminal defendants who are unable to afford their own. The case extends the right to counsel, which had been found under the Fifth and Sixth, to impose requirements on the federal government by imposing those requirements upon the states as well. So yeah, you have a right to counsel under the federal Constitution, but this judgment required states to do it as well. But it was already in the states' deal, in the state's Constitution. But the good old Clarence Earl Gideon. Poor bastard. But anyway, shall we get back to this? Let's get back to this. Let me get rid of this. There we go. Goodbye. Poor drifter. Sorry. I mean, you don't care about. I'm just deep diving here. Watch Gideon's Trumpet. And Inherit the Wind is another good movie. And watch 12 Angry Men while you're watching court cases. There's some good stuff here. Yeah, sorry. I'm going to put it away now. Yes, that's what I was searching for. I found it. What I found was the Abe Fortas was Wainwright was Gideon's lawyer. He was such a good lawyer that he became vice president. I knew it was some president, Vice President Lyndon Johnson's personal lawyer, and he was eventually appointed to the Supreme Court. So yes, the very, very important guy. So that's why he sounded very Clarence Darrow like, because he was a smart guy. Sorry to take all of that time just because I couldn't remember whose lawyer he was before he was on the Supreme Court. There we go. Right. So back to this citation here. Notes on advisory committee rules. Oh, Jesus, where did she find these things? How would she find the notes of advisory committees on rules from 1944? You got a lot of time in jail, I guess. There's not a whole bunch to do. United States Supreme Court. Well, we don't have to read much of this because the defendant's requests are in good faith. Oh, we're at the end. We skipped it here. The defendant is requesting. All right, there we go. Wherefore, Sarah Boone. Aha, we found it. Here we go. Now we're at the meat and bones of this. Wherefore, Sarah Boone, pro se indigent defendant, respectfully requests to the honorable court to provide immediate relief to defendant by appointing effective standby counsel and support him in preparation of her criminal case for trial. I think she would have been better served if she would have asked for another lawyer to be appointed. It may have been denied, but if you start slinging around case law like this, a judge might go, ooh, let's give her one more chance. We don't know, but she probably would have had a better chance asking for a new lawyer. Not that it would be a great chance, but standby lawyer. She has failed to show that she has any legal right to a standby counsel. She's shown lots of cases where she's entitled to have a lawyer appointed to represent her, but a standby counsel is essentially someone that just stands there and helps out if she needs it or if she has any legal questions. She's utterly failed to show any right to have a standby counsel appointed for her. Right, Andrea Ellerby. She's like, nice handwriting, bad spacing. It's like she's got good handwriting, but it's just weirdly illegible. Unless she's angry, then she spaces it out. To be fair, didn't she hit one of her lawyers? I know Shabusiness did. But yeah, you don't walk out on your lawyer. That's not something you want to do. But she's got to show she has a legal right to a standby counsel because she's asking for a standby counsel. She didn't do that. Done. The defendant is requesting collaboration, correct understanding, and overall perspective of, and in her extraordinary circumstances, it ain't all that extraordinary, by rendering her cognitive incapacities. She's got cognitive incapacities now. I think she meets pretty much the standard, the very, very low standard for competency, because say what you want about her. This is actually a pretty her other motions were well written. This is easily first year law student level here. I will give her at least that, because I recall reading some of my law student colleagues stuff that was a lot worse than this. So we'll give her a point for that. She's definitely competent. Her cognitive incapacities, procedural inabilities, and extremely limited capabilities altogether is fact, and concluding a remedy of assistance is rightfully needed to be provided to the defendant by the court. Appointment of vital standby counsel will lessen greatly her probabilities of further loss, damage, spoliation. Ain't nobody going to spoil you. We have to protect against her spoliation and oppression in her criminal case. Fair and equal position by fair and equal opportunity also will be greatly enhanced. The defendant's requests are in good faith, and her merits are worthy in striving to successfully, lawfully, and properly perform, act, thrive, and overcome her forced by the court position of pro se attorney and her representation of self. Conclusion: this motion for immediate relief to defendant by appointing effective standby counsel to aid and support in preparation of her case for trial should be granted. Denied. Sit down. That's how that went. That was indeed denied, as we saw in the other response from JAC. Yeah, you know, you only get so many chances before they go, all right, we're done here. And she had 8 chances. I have never heard of anyone getting 8 appointed lawyers. Like I said, Shabusiness, I think, got 4, maybe 3. It was 3 or 4. She had 8. 8. And then the judge basically says, it's your actions. You're saying it's all them. They're all wrong. They're all bad. They're all, incompetent. They're all ineffective. It's you that's ineffective, Sarah. So, you're walking out, you're arguing, you're calling them names, you're doing all of this stuff. We've given you 8. You can't get along with them. You're done. Yes, to be fair, Sarah is the common denominator. Lady, I'm not going to read that. Yeah, 3 is too many, but 8, yeah. Which trial is first next week, Sarah or Reed? When is Karen's hearing? Sarah's is 8:45 a.m. Eastern time on Monday. I don't know when Karen Reed's hearing is. No, it's the next hearing. Yeah, the trial is October 7th, I want to say. It looks like, Monday is October 7th. So Sarah's 8:45 Monday morning. Yes, that is correct. I'm just trying to remember when. Karen's is August 9th. Okay. That's the one I was thinking was at 2 p.m. Okay, right. I got them wrapped up in my brain. So hers would be Thursday. What is that when it is? Don't know what day the 9th is. The 9th is Friday. All right. So Sarah is Monday. Karen is Friday. And that's it. Yes, Reed has a hearing in August. So it'll be next Friday. Trial is supposed to start in January. But if there's appellate issues, it could get bumped back because it's been over a year since the YNW Melly mistrial. So then that was supposed to start in October of last year. It's now set for trial in September of 2025. So his retrial is going to take 2 years. So this could be bumped back, but we'll just have to wait and see. But Monday, we'll do some Karen reading on Monday. Why not? It'll probably be a short hearing. wouldn't expect it to take too much time. So that's where we are, people. It brings us to the end of another 3-hour, 2-hour show. Oh my gosh. Good to be back on the Sarah Boone bandwagon. It's been a while since we did some Sarah Booning. But we're gonna be on top of it all the way through until trial. Hopefully in October. All she's gonna do is ask for an extension, and I think she's gonna get it. Ask for that continuance, and I think she might get one of a month or two at least. Thank you for your 3-hour tour, Legal Vices. Thank you for joining me. And no shipwrecks today. That might be Monday, depending on how long the hearing goes. So, all right, people, that is it. We're gonna wrap this puppy up. The 466 of you are here. We have 477 likes. The last time I'm going to remind all of you to please do me a favor. Get down there and hit that subscribe button if you haven't done so. And if you have, please double check to make sure you are still subscribed. And if not, re-up. I'm going to look for a place to send us. I don't know where to send us. But let's see where we can go. I'm seeing who is doing what right now. It is noon and I am hungry AF. I'm getting to the hangry stage. Content live. There we are. And go to redirect. Who can we redirect you to now? Nobody's live right now. Why is there nobody live? Is there anywhere anybody wants to go? The expert was live, but he's not now. Moxie Dame is upcoming at some point. We've got lots of upcoming, but nothing going on right now. The expert was live, wasn't he? Is he still? Oh, he is live. Okay. All right. We'll send you over to the expert. Why not? All right. Be sent to the nearest bar. Ooh. All right. That's it. We are ready to go, people. We'll send you on over to the expert. Tell him howdy from Legal Vices. Tell him it's Legal Vices Raid. I am going to march off into the kitchen, make myself some breakfast and lunch all at the same time. And with that, we'll see you on Monday for Sarah Boone and perhaps a Maritime Monday of some sort. We'll play that one by ear, but stand by, hit the subscribe button, sign up for the notification so you know. And how did we end up on our poll? Sarah Boone, 7% of you said is an international human smuggler. Sarah Boone, 14% of you said is the best jailhouse lawyer. She actually is not bad. 25% of you said Sarah Boone, spokeswoman for Samsonite Luggage. And with 54% of the vote, Sarah Boone, just batshit crazy. And on that note, mods, thank you so much. Oh, wait a minute. Corey Boatwright, member for 9 months. Also a huge part of the show today. Thank you so much. She'll quote Robert's Rules of Order eventually. I'm surprised. I'm actually surprised that wasn't in there. I used to know Robert's Rules quite a bit back in the old debate days, but yeah, what a scourge Robert's Rules are. I'm on a board, and they wanted to have the board run by Robert's Rules of Order, and I said, no, you don't. No, you don't. Haven't you seen Congress? Haven't you seen the way Congress does things? You don't want to do it that way. All right, mods, thank you so very much for being here. Thank you for helping out on this Friday evening or Saturday morning or in the middle of the freaking night if you happen to be in Europe. And chat, best chat, always the best chat. The Vice Squad is the greatest chat on the entire planet. Thank you so much for being here and talking amongst yourselves and talking with me and keeping us all company together. Thank you so much for your super chats, for your monthly memberships, your monthly membership chats, and for the gifted memberships. Thank you all so much for the support today. It was utterly unexpected. And I'm grateful to all of you. Thank you. Love all of you guys so much. Say hi to the expert for me, and we'll see you Monday. Bye, peeps.